Okay, you guys ready to roll? Ready? Everyone ready?
Yeah, sure.
Okay, you set? All right, let's go on the record in the Winslow case. The record will reflect we're meeting outside the presence of the jury. All counsel are present. Mr. Winslow is present. We are here this morning to discuss jury instructions, the exhibits, and verdict forms, and we're going to have an 1118.1 motion. Is that correct?
Yes, Your Honor.
Why don't we go ahead and do that now?
Your Honor, we request that the case be dismissed based on Penal Code Section 1118, I'm sorry. And the evidence that was submitted before the court, we'd submit on that.
Okay. Do you want to respond?
Not sure if I necessarily need to, except that I would just refer the court to the evidence from each one of the testifying victims, as well as the ample corroborating evidence as it relates to each one of the charged, the 12 charged offenses, and ask that the court deny it outright. I don't see that there's been anything identified that shows that there's any element lacking for any one of the charged offenses.
Okay. All right, Mr. Watkins, do you want to be more specific at all, or are you just going to submit on the record?
Submit on the record.
Okay, all right. Well, under Penal Code Section 1118.1, the court must dismiss the charges or any charge against the defendant if the evidence then before the court is insufficient to sustain a conviction of such offense or offenses on appeal. The court has sat through this trial, and this is not a close call. The motion under Penal Code Section 1118.1 is denied. The court does find there is ample evidence to sustain a conviction of all of the offenses charged in the information, counts 1 through 12 on appeal. So the motion to dismiss is denied. All right, then why don't we turn first then to the exhibits. Has counsel had a chance to discuss the exhibits?
We've been just looking at the instructions right now.
Okay, you haven't looked over the exhibits yet?
I've looked through the ones that Madam Clerk sent last night to show what has and has not been identified. And I would agree that there are a number that would likely need to be withdrawn by the parties. But other than that, I don't have any issues with the ones that have been identified.
Okay.
We did speak informally yesterday, and we didn't have any issues with any of the already identified and admitted exhibits.
Okay, so exhibits 146 and 147 have been excluded, so those are not coming in. There's been a few exhibits that have not been identified: 3, 18, 19, 50, 160, 161, 166, and 167. Do you want to deem those as being withdrawn at this time? There's been some that have been marked as well that have not been identified.
So, I mean, we still have a case on ours. I don't know if the
Right.
160s are ours, right?
Okay, why don't we do this? Why don't we just reserve on the issue of the exhibits, but I'll order counsel to go over the exhibits before you leave today. I have them all right here. And then we can hit the ground running on Monday. You can agree on what's coming in and what's not. And if there is a dispute, we can address it on Monday morning.
And
What
you're
I could tell the court, just to make things perhaps easier for Madam Clerk, is up to the ones the court identified ending in 50, the people would move to withdraw the ones that were previously marked.
Okay, so 3, 18, 19, and 50 were submitted by the people, and you are now withdrawing those, correct?
Yes.
All right, any objection?
No, Your Honor.
Okay, those will be withdrawn. And 160, 161, 166, and 167 were defense exhibits. I think that those were identified, however. In fact,
Your Honor, they're duplicative of other ones that have been identified, I believe.
okay. I know that 168 and 169 were identified by Jane Doe number 5. Oh wait, those are 168 and 169. We're talking about 166 and 167. That's correct. Those were not identified.
Okay. What are they? Do we know?
They're photos of the exercise machines in Crunch.
But she didn't identify them.
But why don't we do this? I'll have you take a look at them after we recess for the day, and we'll deal with it first thing Monday morning. Okay?
And Your Honor, I told the court that I have a hearing at 1:30. I have to probably leave here about 11:45 because I have to pick up exhibits and
Okay.
documents in order to make it to court at 1:30 because the apparently there's other lawyers are waiting.
Okay.
Imagine that.
That's fine, then why don't we move on to the jury instructions? The exhibits just take some time to go through, and Mr. Watkins and Ms. Barr can maybe do that.
Yeah.
Even if we're still going through the instructions, I have two lawyers here, so.
Okay, all right, then let's move on to the jury instructions. I did receive jury instructions last night from the people. Have you had a chance to review those? Who's handling this? Mr. Carlos?
Yeah,
We all are.
Everybody?
Just look in this direction.
Okay, so I will, I've reviewed the instructions. I will read the number of the instruction. If there is no objection, the court will assume that it is agreed by the defense, that it will be submitted in its current form. If there's an issue, you can object, all right? So, starting with 200, I will give 200, 201, 202, 207, 208, 220, 223, 224.
I'm sorry, Your Honor.
Yes,
Did you do 222?
that was not submitted.
It's included in the.
Oh, it is, yeah, it is, 222.
Okay.
And that includes the portion regarding the stipulation, so it's appropriate. I will give 223, 224, and 225. Typically, the court only gives one of those.
I always submit both and allow defense counsel to elect, Your Honor.
All right?
We're requesting 224, Your Honor.
Any objection by the people?
Your Honor, I think that typically when we have specific intent crimes, circumstantial evidence, the intent instruction is given because, of course, that would apply. Specific intent oftentimes can only be proven by circumstantial evidence, so I think that's the more directly applicable.
Well, the court does have a sua sponte duty to give 225, whether the defense objects or not. And that's based on People versus Urigan at 45 Cal 2nd 46. And this instruction must be given if the prosecution substantially relies on circumstantial evidence to prove the element of a specific intent or mental state. All right, and there are a couple of specific intent crimes in this case, and that is in dispute with respect to the specific intent at the time of kidnapping, and also with the issue of consent. So do you want to be heard on that?
So the court's inclined to use 225? Can't have both.
Yes.
If I could just look at the instruction.
Do you want to talk about it?
I just want to review the instruction one more time.
Right, and we can give both if you want, just to,
Yeah, that's fine, yeah, that's what we.
That's what we request.
you want to do both? Okay, just a moment. All right. I will give 224 and 225. When I say there's a mental state of consent, there's the question of whether the defendant actually believed that there was consent throughout the act of the intercourse. So I think that's a mental state that is important. All right, so I will give 224 and 225. I will give 226. There was the portion left out that dealt with character. Are you requesting any instruction regarding character? We didn't have any opinion or reputation evidence, but it remains to be seen what we hear from Jane Doe number 1's daughter on Monday. Are you fine with 226 as it's currently?
In standard form?
Yes.
Yeah, I'm fine with that, Your Honor.
Okay, all right, then the court will give 226, 252, 300, 301, 302, and with respect to 303, what is that relating to?
I think the court gave an admonition in response to various objections about hearsay, I think 2 stages during the course of the trial, when out-of-court statements were
Well, that's
limited
correct.
for the limited purpose of explaining the subsequent conduct.
All right, any, okay, I'll give 303. There's 315 that deals with eyewitness identification. We're a little early in the stage to determine if that should be given. If your client testifies, it may remove any eyewitness identification issues if he were to testify consistent with your opening statement, Mr. Watkins. So what's your position on 315?
We should reserve on that.
All right, I'll reserve on 315, and we'll address it after the conclusion of the evidence. I will give 318.
I'm sorry, Your Honor, 316B.
What other conduct are you referring to? That refers to other conduct that does not amount to a felony that would reflect
Correct,
on
Jane
credibility?
Correct, Jane Doe 1s, drunken publics.
Not to mention her perjury, Your Honor. I mean, she took the oath, said that she'd been sober for 30 years, and clearly she's not. And I think
Well, that's if you believe her daughter. So the drunken publics do not amount to a crime of moral turpitude and does not reflect on credibility. However, if the jury finds that she perjured herself, then that would certainly be something they could consider.
We consider it other misconduct. Doesn't necessarily have to be a criminal conviction. And we have to prove that she did lie about being an alcoholic, where she's been arrested at least 5 times that was submitted to the jury.
Your Honor, I think,
Within the 30 years where she's not supposed to have been drinking.
well, Your Honor, it is legal to drink, but first of all, I would just state that under 226, it does include the bullet point of has the witness engaged in other conduct that reflects on his or her believability, as would be standard in most situations. I don't think that 316 is applicable to this case specifically because of the reason the court identified, which is that public intoxication is not a crime of moral turpitude that would reflect on a witness's credibility, and therefore there's no reason to give the more specific instruction under 316. They can argue all they'd like that she may have committed perjury or that she lied to this jury, whatever they choose to do. That's already addressed by the other instructions, and that's really a factual matter for the jury to decide. That doesn't require the giving of 316.
Correct. I agree that being drunk in public is not a crime of moral turpitude. However, lying about it is something that the jury can consider in assessing her credibility. She does not have a conviction for perjury. The daughter testified that in her opinion she committed perjury, but there's no conviction of perjury, and it does not amount to other conduct that's contemplated under Law&Crime 316. So the court will note the request for 316 by the defense, and the court will deny the request.
Your Honor, my position is I don't think 316 is confined to crimes of moral turpitude.
And what case law do you have that would support that?
Well, I don't see any case law that says it is confined to crimes of moral turpitude. The plain language says other misconduct. And that's misconduct.
Right, misconduct, it necessarily, in order to reflect on credibility, must involve moral turpitude. So if she got a speeding ticket, that's not misconduct that would reflect on her credibility. If she did some other crime that does not, for example, possession of methamphetamine, that's misconduct, but it does not reflect on her credibility. It has to be a crime of moral turpitude, like theft, burglary, perjury, fraud, things like that, and being drunk in public and being unable to care for yourself does not reflect on her credibility. So the request for 316 is denied. All right, the court will give 318, 332. I will give 355 if the defendant does not testify. That is the defendant's right not to testify, and I'll reserve on that until Monday at the conclusion of the people's case. If the defendant does testify, I will not be giving 355. All right, I will give 358. I will give 359, and I'll reserve on 361. Correct, Mr. Owens?
Yes, Your Honor, and depending upon Mr. Winslow's decision on whether he wants to testify, does the court plan to give 358 and 359 regardless?
Oh, yes.
Okay.
Because he did make statements that were admitted into evidence both to Jane Doe number 1, 2, well, all of them.
Understood.
So those statements, the court has a sua sponte duty to give 358 and 359.
And then I would agree that 361 is dependent on his decision.
Correct. Well, and if he does testify, it doesn't mean the court will give 361. However, if during his testimony he fails to explain or deny evidence against him, and he could be reasonably expected to have done so based on what he knew, then I'll instruct the jury they can consider that in evaluating the evidence. But I will withhold on that. All right, 371, the suppression of evidence, and that is related to what? Hiding the Hummer and wiping out the Strava account?
It would be both, and it would also be the detailing of the Hummer that took place the day after he had his DNA swabbed by law enforcement.
Okay, all right, any objection to 371? It's consciousness of guilt by suppression of evidence, that the defendant tried to hide
We would
evidence.
object to that, saying that he tried to detail the Hummer. This is 3 months after this alleged bleeding all over his vehicle. So I don't see there's a connection between cleaning the blood out of the car allegedly 3 months after versus a normal detailing. We haven't had any evidence that suggests that this was somewhat directly related to concealing this crime. Like I said, this did happen 3 months after Jane Doe 1 allegedly bled all over the vehicle. And as far as clearing the Strata app, that account was deleted. There's no evidence that he knew that it was stored or anything like that that would be connected to that crime. These are just normal actions, activities that he did that are now being connected back to the crime. But to say that there's a relationship between the two, I don't think there is.
Okay, well, the detailing and selling of the Hummer and apparently dumping it up in San Carlos for some period of time could be considered by the jury as evidence of attempting to hide his guilt. The timing is interesting in the sense that his mouth was swabbed and the next day he has the car detailed. So it may have been a trigger knowing that the police were onto him and he had the car detailed the very next day. So the court will give 371. The court will also instruct the jury that it's up to them to decide its meaning and importance, and they will. They can also determine whether or not the defendant made such attempt. If they decide that he didn't make such an attempt, then they are not going to consider it for consciousness of guilt. So the court will give 371 over the defense objection. All right, 372 concerns defendant's flight. If the defendant immediately fled after the crime was committed, that conduct may show that he was aware of his guilt. And what's your theory for this? For which count?
Jane Doe's 1, 2, and 3, not the others. If we want to be more specific, we can. But Jane Doe's 4 and 5, there's no evidence of flight.
And we would strongly object to that. There's no evidence of flight of Jane Doe 1, 2, or 3.
Well, for Jane Doe number 2, he left her on the side of the road and took off.
Well, taken off is a very strong word. I mean,
well, he left and left her on the side of a dark road and fled the scene.
After threatening to kill her if she reported it to anyone. In the same vein, Jane Doe number 1 stated that the moment that he had finished what he had been doing, he kicked her out of the car and then drove off, that she saw him speed off out of the parking lot. Jane Doe 3 testified that as soon as she started screaming, "My husband, my husband, my husband," he then turned and left the area as well. So I think that there's ample evidence of flight, and people think the instruction's appropriate.
Right. Well, yeah, go ahead, Mr. Watkins.
I don't believe there's any flight here. I mean, he has to resume his normal life. He can't stay on the scene indefinitely. So flight entails, I'm going to call the cops, you did this to me, and then fleeing the scene. But resuming your life, he couldn't stay on the side of the road. He couldn't stay in that shopping center indefinitely. He couldn't do these things. I mean, he just resumed a normal life. He went home. He was at home. He was living his normal life. That's not considered flight.
All right. Well, the court finds that the flight instruction is appropriate for Jane Doe number 1. He left her behind a shopping center and took off, did not take her to where she wanted to go, and he left her there. It wasn't like he had a sexual encounter with her and then he dropped her off or he picked her up. He fled the scene and left her there by herself. With respect to Jane Doe number 2, he left her on the dark road out in the middle of nowhere and he took off. And then with respect to Jane Doe number 3, we have evidence in court exhibit number 86 that he was right across the street from her house and then left on his bike ride. We know exactly where he went. He took off and went for a long bike ride. So he...
That's my point. How can he, if he went for a bike ride and he does in fact do his bike ride, how can that be considered flight? He's doing his bike ride.
Because he left when Jane Doe number 3 started yelling at him, and right after he exposed his penis to her. It wasn't as such as if they sat down and drank tea afterwards. He fled the scene as quickly as possible once she reacted the way she did. So the whole point of the instruction is if there's some misunderstanding, say, look, I'm sorry there was some misunderstanding of some sort, but it's relevant to counts 1 through 6, and I will note that I will instruct the jury that if they conclude the defendant fled, then they can then determine the meaning and importance of the conduct. So it's a conditional instruction. I'm not instructing them that he fled. The court will instruct them that if they find that he fled, then they can consider that. So the court will give 372 over the defense objection. All right, then we have 375. Now this deals with 1101B. Do you want to be heard on your argument that it's sufficient to show identity?
Your Honor.
And the other areas which yours, in the intent as well?
Yes, Your
I thought
Honor.
we dealt with this in the pretrial motions, but I think we're reserved to see how the evidence would come out, correct?
That's correct, Your Honor. And in terms of 1101B, I identified each of the charged offenses. Of course, the court did not allow introduction of evidence for some of the uncharged conduct. But I think that 1101B evidence allows the jury to consider even charged crimes in determining whether one or the other, if it's been committed by preponderance, then they can then apply it to determine whether or not the defendant committed the other offenses that have been charged. So that's why I worded it in the way that I did as evidence of offenses to prove identity, intent, and lack of reasonable belief and consent. I think that the identity purpose, I'll submit to the court. It doesn't sound as though there's going to be a significant challenge to ID based on the state of the evidence. The one and only that I think is particularly important where ID may be an issue is Jane Doe number 3 in count 6. And that certainly would be, 1101B would certainly apply for that offense with the commission of the lewd act in public for Jane Doe number 5. I didn't get into the specifics of each one and its applicability and how it could be corresponded because I thought it was best to leave it as close to the pattern instruction as possible. And
Wait, so are you offering to prove ID for Jane Doe number 3? Because there's not a signature mode of committing that crime that can be tied into the other ones.
Well, I think that the commission of the lewd act in public can be used as evidence of the identity of the perpetrator in the Indecent Exposure Act, especially given the way in which they occurred, the victims themselves who had been selected, as well as the descriptions that had been given. So the fact that someone matching the description unknown to Jane Doe number 5 committed this type of lewd act in her presence, directing the attention of Jane Doe number 5 to his genital area at the time, then can be used to prove identity of the perpetrator of the indecent exposure with Jane Doe number 3, who gave a very similar description, and the individual engaged in very similar conduct, this time actually exposing his bare penis to her. So that's why the people included the identity purpose.
All right, well, so it's your position then that the crimes are sufficiently similar to allow the jury to consider it for purposes of identity?
Yes, both in the elements of the offenses as well as the specific conduct that's been established in the record. Both in the elements of the offenses and the specific conduct that's now been established in the record.
All right, well, there has to be a high degree of similarity to prove identity. We have 2 ladies who are older. One of the incidents occurred inside a gym. Another one occurred in the front yard. One, the defendant was on his bike. Another time he was working out inside the gym. In one case, he exposed his penis. In another case, he didn't. It seems like there's a lot of dissimilar type features that would not allow the court to find that they're sufficiently similar to prove identity. Identity requires the highest degree of similarity if you're offering for that. So do you want to be heard further on that?
No, Your Honor, I'll submit.
All right, so the court will deny the request to allow the identity issue under 1101B. And I don't know what the defense is going to be. It seems that it might be identity for count 6, but we have exhibit number 88, which shows that he's in her front yard on a bike ride. So I don't know if the defense is identity or not, but it shows, assuming he's going on a right side of the street, he does a U-turn, goes in her front yard, and then leaves. So I know that was not the date of the offense, but it shows that he was there. So I don't know. I don't know what the defense is going to be. If it's going to be identity or he didn't do the act.
And that's based on the opening statement that people have to be able to prove beyond a reasonable doubt the identity of the perpetrator, and defense counsel essentially implied that it wasn't him. And
Okay.
he didn't say it outright, but he said that Jane Doe number 3 is not going to accuse Mr. Winslow of anything because she doesn't know who did it.
Okay.
So that seems to be going to identity.
The problem is, like the court indicated, is that it has to be almost like an MO, like a signature type.
Correct.
And it's not in this case.
All right.
because-
So I'm not going to allow for identity, and that deals with the 352 analysis. The court has to, it has to go through a 352 analysis. It doesn't survive for identity. Now, you've also suggested other reasons to allow it. It's for purposes of intent, and for the lewd act in public, the people have to prove that he touched his genitals or exposed or engaged in an act with the intent to sexually arouse or gratify himself or another person, or to annoy or offend another person. Are you suggesting that it should be admissible for that purpose then?
Yes.
For
And-
which count?
So that's what I included in the instruction is the specific intents that are required for the kidnapping being for the purpose of rape or oral copulation, and then also the intents to sexually gratify himself or sexually offend or annoy another person for the indecent exposure count, count 6, and the 2 lewd acts in public counts of 9 and 10.
All right, and this is a different type of analysis. We don't have to show the high degree of similarity as we have to show for identity. So the question then is, do those multiple acts reflect on the intent for the others? And we're in a different situation here when we're in trial, when there are charges that are contained in the same case. In other words, we're not bringing in a separate act and bring it in to show how he acted on the other uncharged offense. This is these are charged offenses, so the prejudicial effect is lessened, and it could be argued that it is highly probative on the issue of intent. So, who wants to be heard, Mr. Watkins or Mr. Carlos?
Your Honor, first of all, this instruction has traditionally been used for uncharged offenses, right? So
Correct.
with
And it's just like 1108, it's evidence of another offense. The fact that it's a charged offense is, as I said, makes it less prejudicial because the
Right.
jury's already heard about it.
Except the problem that we have is that this is an attempt by the prosecution to just have the jury believe that essentially where there's smoke, there's fire. You can use whatever strong evidence from one count to bolster the weak counts. And what's problematic here is that, the second paragraph is you may consider this evidence only if the people have proved beyond a preponderance of the evidence the defendant in fact committed the offenses. So rather than because this is reserved for uncharged acts, the jury in uncharged acts finds a preponderance of evidence and then uses that to determine whether the defendant is guilty beyond a reasonable doubt. But in this case, those are charged offenses, and essentially the jury's going to get confused because they're told here that they can just go by preponderance of the evidence. So I think what it does is it lessens the burden on the prosecution to prove the independent charges beyond a reasonable doubt. What this does is tell the jury that you don't have to do that. You can find a preponderance of the evidence in all of these counts to make each one beyond a reasonable doubt. And I think that's unfair.
Okay, well, we addressed that in 1108. You, Mr. Owen, submitted instruction that changed it from preponderance of the evidence to beyond a reasonable doubt. Do you want to do the same in this?
No, Your Honor, because I think the correct statement of law is that if the jury finds by a preponderance of the evidence of one count, for example, count 2 involving Jane Doe number 1, if they find that he committed a forcible rape of Jane Doe number 2 only by a preponderance of the evidence, they can use that evidence, at least that what has been introduced, to determine whether or not they believe that he committed or had the requisite intents to commit the other offenses that are charged.
That's correct.
So I think that it can be addressed in argument, that the instruction is properly given in that way, and the jury is able to use all of the evidence that's been presented if they believe an act has been committed by a preponderance standard to then potentially find beyond a reasonable doubt for the other acts.
But there's no way to, but there's no restriction. In other words, they can just find beyond a preponderance, they can find a preponderance of the evidence, which is the lowest standard of evidence possible, right? And use that all across the board and say he's guilty of all of them beyond a reasonable doubt, which is improper.
Well, they can use that as one piece of evidence to establish whether or not he had the requisite intent. This in and of itself is not determinative of the intent. They have to consider the acts as well, and it's not used without restriction. The jury instruction says do not consider this evidence for any other purpose. However, that would have to be modified because you have to consider it for propensity. So I'm inclined to give this instruction with respect to proving intent. So do you want, but here's what I'll do. I understand it is a charged offense. Do you have a case that states that you cannot use it for charged offenses?
Your Honor, if we could reserve on this.
That's what I'm.
Research on this, because this is way too important. There's
Right,
no way a jury's gonna be able to splice, I find this by a preponderance, so now I'm gonna find this other charge using this preponderance evidence, guilty beyond a reasonable doubt, and now that he's been guilty of a reasonable doubt here, I can go back to this charge and raise this preponderance up to beyond a reasonable doubt. I mean, that's what the jury's gonna do. It's gonna be absolutely, completely confusing, and it conflicts with 3515, the multiple offenses instruction. So if we could reserve on that, I'd like to even maybe do a little mini brief on that.
That's fine. You can email me your brief over the weekend or tonight, whenever you want to do it. But in the meantime, I'll ask you, Mr. Owen, to submit a new 375, deleting the reference to identity. The next question is whether or not it's admissible to prove a reasonable and good faith belief. It's not admissible to prove whether it's reasonable or not. That's an objective standard. The most it would be allowed to prove whether he honestly believed the victims consented. Do you agree or not?
I don't, in terms of the court's question regarding reasonableness, because that does specifically, that is part of the pattern instruction, and one of the specifically enumerated purposes for 1101B evidence is to determine whether or not the defendant himself reasonably and in good faith believed that Jane Doe 1, 2, and 4 consented to the charged offenses and acts. The jury can consider whether or not the commission of a forcible rape against Jane Doe number 2 would, in a person who has committed that offense, was reasonable in their belief and consent when they're arguing that Jane Doe number 1 had consented. So it goes both to the actual and good faith belief of the perpetrator as well as the reasonableness of that mental state at the time.
Because it's a same person under similar circumstances?
Yes.
Okay. All right.
Same perpetrator or the same victim?
Well, it seems to be more probative on whether he had actual belief in consent.
And that can be argued, but it also is informative of the reasonableness of that belief at the time.
All right.
I mean, do you understand the danger of this instruction? It's highly confusing. I mean,
Well,
there's multiple parts to it.
It's a good instruction for the prosecution. That's why they want it. The question is it allowed by the law? And I'll follow the law. And if the law says it can be given, we'll give it. If not, we won't. So here's what we'll do. Mr. Owens, please submit a new 375. Delete any reference to identity. Leave the last two in with respect to intent and good faith belief. Also, you need to amend it in the portion where it says, do not consider this evidence for any other purpose. It has to be changed to allow the jurors to consider it for purposes consistent with Evidence Code Section 1108, which would be, you could just refer them to the jury instruction on that particular.
Your Honor, what I would include, if I can just propose the language, if I can make that change right now, is do not consider this evidence for any other purpose other than what I have defined for you in
Cal Crim 1191B.
and I've done that already.
Okay, so you can submit that, and then Mr. Watkins and Mr. Carlos, you could submit a brief on that, and we'll just address this issue Monday morning at 9.
Sure.
All right, that's why I wanted to take an hour, because I knew there were going to be some issues that would arise, but I will reserve on that. All right, then we have 1194. The court will give that, and it's specific to Jane Doe number 4, which deals with prior consensual sexual intercourse. Any objection to that? Or I'm sure the defense wants that, correct?
No objection.
Okay, so I'll give 1194. Then we'll move on to count 1. I will give 1203. I will give 1215. That's a lesser included offense. Any objection to the LIO for count 1?
Your Honor, and that would actually apply to one of the one strike offenses that have been alleged anyway. So we have to define it as, in terms of simple kidnapping. That's one of the secondary
Right.
offenses under counts 2, or allegations under counts 2 and 3. I included it as a lesser included offense, assuming that the defense would want to.
Well, for the one strike, it has to substantially increase the risk of harm.
Well, that is only for the aggravated kidnapping one strike. Both are alleged. There is a separate
Right.
simple kidnapping one strike.
Right. So, okay. Any objection to 1203? I'm sorry, 1215?
No, Your Honor.
Okay. And then the next one in order is CalCrim 1000. There was language that was left out that the court feels should be given, and it deals with In re John Z. at 29 Cal 4th 757, because specifically with respect to Jane Doe number 4, during the cross-examination, it appeared as though there was a suggestion that Jane Doe number 4 initially may have consented to the initial penetration. And then maybe withdrew it, because it certainly sounds like the defense is suggesting that she was conscious when she was on all fours. In Ray John Z, it's a bracketed language that talks about someone who initially consents to an act of intercourse may change their mind and has to communicate through words or acts that she no longer consents, and then the defendant forcibly continues the act of intercourse. So,
But Your Honor, there's zero evidence that actually took place. It's just the implication and innuendo from cross-examination. I don't think that we have any evidence whatsoever to support that right now, and the inclusion of that bracketed portion would be solely based upon Mr. Carlos's questions. And there has been no affirmation and no affirmative evidence that actually happened.
all right, is the defense requesting that or no?
Yes.
You are requesting it?
Yes.
Okay,
and
well.
it's based on her own words. I mean, she indicated that she was wondering what she may have started.
But that's correct, but you understand that if she did, let's just assume the jury finds, based on that one statement, that she may have consented to initial penetration. I think she made it clear that she withdrew her consent, and she said that he was still forceful with her and continued the act of intercourse against her will. That would be a forcible rape. So do you want that language? It sounds like Mr. Owen's not asking for it.
Let's see, hold on a second.
So are you requesting that language? But I will say it also depends on whether or not Mr. Winslow testifies. If Mr. Winslow testifies that she consented to the initial sexual penetration, and there was consent, then it will certainly be given. But you're not requesting it now, correct, Mr. Owens?
I am not, and I don't think that there's any evidence of consent
All
whatsoever.
right. The defense, are you requesting it at this point?
I'm reading the commentary right now, Your Honor. Can I just 1 second?
Sure. There were two Court of Appeals decisions that had conflicting results. One is People versus Vila, and one is People versus Roundtree. One said that the initial penetration that was consensual.
We'll withdraw that.
Okay,
request.
all right, so it will be given in its current form unless Mr. Winslow testifies and raises that issue. So I'll flag this one, but otherwise, Calcrum 1000 will be given in its current form. Next is 1015, the court will give that. 1030, 1160, 1003, 1161, 831, 841, 1190, and then we have 1191B. And in this one, the people changed the language from preponderance of the evidence to beyond a reasonable doubt. And that's how you want to give the instruction, correct, Mr. Owens?
Yes, Your Honor, and in fact, that's actually the standard instruction as a B alternative when it is charged offenses.
Okay, any objection to giving this instruction? Any objection?
Just one more.
Okay.
This is the doctrine uncharged evidence instruction, right?
No, it is evidence of charged sexual
Right, but
offenses.
this used to be-
1191A deals with uncharged
Uncharged.
offenses. And he submitted B. And the court did double check, Mr. Owens did include only those offenses that are allowable under 1108. In other words, he did not include the lewd act in public, and did not include willful cruelty to elders or battery against an elder.
On the instruction, Your Honor.
Okay, the court will give 1191B. Next is the special allegation for 7 and 8 as well as 3410. Both of these relate to the statute of limitations instruction. The court has reviewed People versus Rilabola, which is Ruiloba. It dealt with this issue, and we talked about this in the pretrial motions as to whether or not there should be a bifurcated trial. The court ruled at the time that we would not bifurcate the trial since it would be the same evidence that would be presented. The court in Rubiola stated that the better course would be to include the elements of the statute of limitations definition in the crime, and the court emphasized that you should not even tell the jury why those elements are present. The court stated the jury's job is to find the facts, and the jury does not need to be told the legal consequences of its findings. The court stated there would be no need to refer to statute of limitations. The jury only need to be instructed as to what types of facts they should find. The court cautioned that telling the jury that its findings on guilt in effect would be set aside unless the jury also found the statute of limitations was extended carried the potential for irrelevant speculation and jury nullification. The court went on to state that telling the jury about the effect of the statute of limitation finding could invite speculation about punishment and whether the defendant might escape the punishment. So the court feels strongly, based on that language, that we should not label this instruction statute of limitations, because then they would clue in that if they find that allegation not true, they might be inclined not to do that and give Mr. Winslow the benefit of the doubt. So I think that the original instruction that was submitted that does not reference the statute of limitations should be given. It's entitled Special Allegations Count 7 and 8. The court feels that 3410, which has statute of limitations written all over it, would invite the jury to disregard the law, because if they find him guilty of those two crimes, they might think he shouldn't escape punishment because of a technicality. So what's the defense position?
This special allegations count 7 and 8, we have a problem with that last paragraph of their definition of independent evidence.
Okay, what do you suggest? Do you want to address it on Monday?
We could address it on Monday. Actually, on our verdict form, we put a definition, and that's really how we think it should read. Does the court have that?
Yes. All right. Well, I think that on the verdict form, there just need to be findings, not instructions. So you're
Right.
requesting that independent evidence is evidence different and apart from Jane Doe number 4 statement.
The definition of independent.
Your Honor, that's not a correct statement of law, and it doesn't come from any case authority.
Okay, let's do this. Let's address this issue on Monday. I'll allow you both the opportunity to brief it. There is not a lot of authority on this. I don't want to state, for example, the court made its own findings on this issue during the 995 motion. The court did find that there was independent evidence, but we can't point them to certain evidence. We can't say, for example, the photograph of Mr. Winslow and Jane Doe number 4 on the night of the alleged offense is independent evidence. We can't give pinpoint instructions. They need to be broad.
Right. That's what the people's instruction does. It
Well, no,
points them to evidence and say it may include evidence of defendant's sexual misconduct.
Well, that is an issue that was addressed in 995 and also during the preliminary hearing. And Judge Elias found that under 1108, that could constitute independent corroborating evidence. And the court also relied in that in part, but found that there was also other independent evidence as well.
And Your Honor, that last paragraph with the definition of independent evidence is a direct quote from People v. Mabini, M-A-B-I-N-I, at 92 Cal App 4th, 654.
All right. Why don't do you have that site, Mr. Watkins?
Yes.
I'm sure you've read it.
And we would like to.
Because it was briefed in the 995.
Correct, and we would like to brief that and do it
All right.
on Monday.
Let's reserve this issue to Monday, but just to start with, do you have any objection to the court not giving the instruction that mentions statute of limitations? All right, and do you want to withdraw? It's 3410. You want to withdraw that, Mr. Owens?
Oh, yes, that wasn't the people's submission. I just did it on behalf of the defense.
Oh, was this the defense submission?
No.
We don't want that.
So nobody submitted it. It just ended up in the court file.
I was asked to include it.
Okay, all right. We all agree 3410 is withdrawn, so 3410 is withdrawn. And then we'll have briefing then on the issue of what constitutes independent evidence. All right? I will give 3175, 3179, 3181, 3515. I will also give the LIO instruction of 3517 and then 3550. All right, are there any other special instructions that are requested by the people?
Your Honor, I know we do have some time. I know Mr. Carlos needs to get going, but as it relates to the special allegation instruction, I want to make sure that everyone is in agreement that the only two factual elements that are being included in that instruction are whether the crime involves substantial sexual conduct and whether there is independent evidence that clearly and convincingly corroborates the victim's allegation. There are additional requirements that are really more legal issues under 803F, that being the commencement of the prosecution within 1 year, of the initial report to the California Law Enforcement Agency. I think based on our discussion, we want to not put that before the jury because we don't want the technicality issue that the court was identifying, and I just want to make sure that counsel is comfortable with this specific instruction on those two factual issues of the substantial sexual conduct and the independent evidence, and that's why we included that in the verdict form proposal as well, just those two portions of the overall 803 F requirements.
All right. Well, the court feels that the independent evidence is the only real issue here. I don't think anyone would argue that forcible rape and rape of an unconscious person does not constitute substantial sexual conduct, but we'll leave it in there. Mr. Watkins, Mr. Carlos, Ms. Barr, are you asking for any other factual determinations by the jury with respect to filing the case and when it was reported and so forth?
No, Your Honor.
All right, so we will deal only then with those two issues, substantial sexual conduct and independent evidence in the instruction. All right, then are there any other, I'm sorry?
Did the court say 3515 was in there? I missed that one.
Yes.
Okay.
Yes, it's here.
Okay, thank you.
All right, and we will get back to work Monday morning at 9. Are there any other issues that we need to resolve now on the record?
If we can we address the proposed verdict forms that have been submitted?
I have not had a chance to look those over. They were just handed to me before I took the bench.
Okay.
Do you have any objection to the verdict forms? Is there?
No, I didn't get a chance to look at them either.
All right, we'll deal with those on Monday too. But take a look at them, and so Monday morning at 9 o'clock, we are going to deal with the statute of limitation instruction, the 1101B issue, and I think that's it, right? Okay, so Mr. Carlos, you can take off, and I'll just ask Mr. Watkins and Ms. Barr to stick around with Mr. Owens and go through the exhibits. I have all the exhibits right here. They're in order, and if you're in agreement, kind of write out what we're agreeing that comes in and what's withdrawn. If there's an issue as to one or more of the actual exhibits that need to be litigated, make a note of that, and we'll deal with it Monday morning at 9. All right? And Mr. Watkins or Mr. Carlos, you can email me your legal authority over the weekend. I'd rather have a chance to look at it over the weekend or tonight, even if you have it done tonight, rather than waiting to serve it on us right at 9 o'clock. And
Oh, no,
do this.
you'll have it before then.
Okay. Any other requests?
The last thing I would say, Your Honor, is I'm emailing right now the amended instruction 375 with the included language that you asked for.
Okay. All right, we'll print that out, and you copied counsel as well?
Yes, of course.
All right. Okay, thank you very much. We're in recess. We'll see everybody back here Monday morning at 9 o'clock, and I'll have the defense. You need to have all your witnesses lined up and ready to roll right at 10 o'clock, okay?
Yep.
All right, we're in recess. Thank you.